The law of Japan refers to the entirety of the legally achieved norms in Japan. Historical developments. Pre-modern history. The early law of Japan is believed to be heavily influenced by Chinese law. Little is known about Japanese law prior to the 7th century, when the Ritsuyo was developed and codified. Before Chinese characters were adopted and adapted by the Japanese had no known writing system with which to record their history. Chinese characters were known to the Japanese in earlier centuries, but the process of assimilation of these characters into their indigenous language system took place in the 3rd century. This was due to the willingness of the Japanese to borrow aspects of the culture of continental civilizations, which was achieved mainly via adjacent countries such as the Korean kingdoms rather than directly from the Chinese mainland empires. Two of the most significant systems of human philosophy and religion, Confucianism and Buddhism, were officially transplanted in 284 to 5 and 522 AD respectively, and became deeply acculturated into indigenous Japanese thought and ethics. David and Zweigert argue that the old Chinese doctrines of Confucius, which emphasize social, group, community harmony rather than individual interests, have been very influential in the Japanese society, with the consequence that individuals tend to avoid litigation in favor of compromise and conciliation. In addition, it is presently believed that various arts and techniques in many fields of production, such as agriculture, weaving, pottery, building construction, medicine and tanning, were brought to Japan by immigrants by way of the Korean peninsula. These immigrants, wherever they came from, had significant influence on the development of Japan. It is theorized by some that the flow of immigrants was accelerated by both internal and external circumstances. The external factors were the continuing political instability and turmoil in Korea, as well as the struggle for central hegemony amongst the Chinese dynasties, kingdoms, warlords, invasions and other quarrels. These disturbances produced a large number of refugees who were exiled or forced to escape from their homelands. Immigrants to Japan may have included privileged classes, such as experienced officials and excellent technicians who were hired in the Japanese court, and were included in the official rank system which had been introduced by the immigrants themselves. It is conceivable, but unknown, that other legal institutions were also introduced, although partially rather than systematically, and this was probably the first transplantation of foreign law to Japan. During these periods, Japanese law was unwritten and immature, and thus was far from comprising any official legal system. Nonetheless, Japanese society could not have functioned without some sort of law, however unofficial. Glimpses of the law regulating people's social lives may be guessed at by considering the few contemporary general descriptions in Chinese historical books. The most noted of these is the record on the men of war, which was found in the Wei history, describing the Japanese state called Yamatai ruled by the Queen Himiko in the 2nd and 3rd centuries. According to this account, Japanese indigenous law was based on the clan system, with each clan forming a collective unit of Japanese society. A clan comprised extended families and was controlled by its chief, who protected the rights of the members and enforced their duties with occasional punishments for crimes. The law of the court organized the clan chiefs into an effective power structure, in order to control the whole of society through the clan system. The form of these laws is not clearly known, but they may be characterized as indigenous and unofficial, as official power can rarely be identified. In this period, a more powerful polity and a more developed legal system than the unofficial clan law of the struggling clan chiefs was required effectively to govern the society as a whole. Yamatai must have been the first central government which succeeded in securing the required power through the leadership of Queen Himiko, who was reputed to be a shaman. This leads to the assertion that Yamatai had its own primitive system of law, perhaps court law, which enabled it to maintain government over competing clan laws. As a result, the whole legal system formed a primitive legal pluralism of court law and clan law. It can also be asserted that this whole legal system was ideologically founded on the indigenous postulate, which adhered to the shamanistic, political belief in polytheistic gods, and which was called kami and later developed into Shintoism. Masaji Chiba, Japan, Polington, Asian Legal Systems, Butterworths, London, 1997 at 91. Two qualifications can be added to these assertions. First, some Korean law must have been transplanted, albeit unsystematically. This can be seen by the rank system in court law and the local customs among settled immigrants. Second, official law was not clearly distinguished from unofficial law. This was due to the lack of written formalities. Although court law was gradually emerging into a formal state law as far as central government was concerned. For these reasons, it cannot be denied that a primitive legal pluralism had developed based on court and clan law, partially with Korean law and overwhelmingly with indigenous law. These traits of legal pluralism, however primitive, were the prototype of the Japanese legal system, which developed in later periods into more organized legal pluralisms. Modern developments in Japanese law today. The early modernization of the Japanese law was primarily based on continental European legal systems and lesser Anglo-American elements. At the beginning of the Meiji era, European legal systems, especially the civil law of Germany and France, were the primary models for the Japanese judicial and legal systems. After the Second World War, the Japanese legal system underwent major reform under the guidance and direction of occupation authorities. American law was the strongest influence, at times replacing and at times overlaid onto existing rules and structures. The Constitution, criminal procedure law, and labor law, all crucial for the protection of human rights, and corporate law were substantially revised. Therefore, the Japanese legal system today is essentially a hybrid of continental and Anglo-American legal structures, with strong underlying flavors from indigenous Japanese and Chinese characteristics. While historical aspects remain active in the present, Japanese law also represents a dynamic system that has undergone major reforms and changes in the past 2 decades as well. Precedent. In the civil law system of Japan, judicial precedent provides non-binding guidance on how laws should be interpreted in practice. Judges seriously consider precedent, especially any pertinent Supreme Court decisions, thus making understanding of precedent essential to practice. Civil law. The Civil Code of Japan was created in 1896. It was heavily influenced by the first draft of the German Civil Code and the French Civil Code. The code is divided into 5 books. Those on family and succession retained certain vestiges of the old patriarchal family system that was the basis of Japanese feudalism. It was in these sections that most of the post-war revisions were made. At that time it was considered no longer necessary or desirable to pay such homage to the past, and the sections dealing with family law and succession were brought closer to European civil law. It has had a significant role in the development of civil law in several East Asian nations, including the Republic of Korea and the Republic of China. It remained substantially unchanged even after the American occupation in 1945, except for the 5th and 6th sections, which were fully revised during the occupation. Contracts. Japanese contract law is based mostly on the Civil Code, which defines the rights and obligations of the parties in general and in certain types of contract. Kawashima writes that civil code theory requires the contractor to complete the work of construction at the agreed price, and that until then the contractor bears the risk of all expenses. But he notes that pre-war public works contracts had stipulated a possible shifting of a burden from the contractor to the owner of the works in the event of an act of God, albeit at the discretion of the owner. Kawashima does not spell out that the contractor will be excused from contractual liability by an act of God under Art 415 of the Code, and the novice needs the guiding hand of academic theory to readily draw that implication from the words of the provision. Nor does he spell out that the owner is relieved from making payments under Art 536, a rule that extends to all bilateral contracts, including the contract for work. A reader must then know that the contractual stipulation allowing the discretion to vary the effect of those code provisions, so that the owner may share some of the loss, is acceptable because those provisions are classified by theorists as optional rules. The relational contract theory, developed by Ukeda from the start of the 1990s, identifies the perceived gap between contemporary social practices and the legal values of classical contract law in Japan. Ukeda further argues that the Japanese legal system now reveals communitarian values that deviate from the modern paradigm of values of individualism and freedom, but which should now be seen as normatively appealing. Ukeda's latest restatement of his theory begins by arguing that contemporary contract law faces problems at two distinct levels: that of contract practice or social reality, and that of contract norms. Following Dworkin very closely, Ukeda assumes that the law retains integrity at the level of contract law principles. He then extends 6 duties emerging through the case law on Art 1 of the Civil Code: the principle of good faith, damages for breaking off contractual negotiations, duty to disclose information, duty to renegotiate, duty to mitigate, duty not to terminate contractual relations without good cause, and adjustment in awards of damages. These are seen as expressing an underlying principle of continuity in contractual relations that is incompatible with classical or modern contract law. Torts. In 1990, the Law and Society Review published an article by Takaro Tanase titled "The Management of Disputes: Automobile Accident Compensation in Japan." It posited that the calculated structuring of governmental and legal processes, not a cultural propensity toward harmonious social relations, accounted for the persistently low litigation rate in that country. In Japan in 1986, Tanase observed fewer than 1% of automobile accidents involving death or an injury resulted in tort litigation. In the United States, the comparable figure was 21.5%. The disparity did not reflect passivity on the part of Japanese accident victims. They commonly made claims based on tort law, and they received compensation from negligent drivers and their insurance companies. The litigation rate was low, Tanase said, because Japan provides non-litigious methods of assessing fault, advising victims of their legal rights, determining the appropriate level of compensation, and ensuring payment. Tanase described how, before a court case is filed in Japan, contested claims generally are resolved by non-litigious dispute resolution mechanisms. These include traffic accident dispute resolution centers, which along with courts, provide mediation services. Claimants can also turn to a network of consultation centers operated by governments, the Bar Association, and insurance companies. The mediation services and advice centers work effectively because the Japanese judiciary works hard at developing clear, detailed rules that guarantee virtually automatic, predictable, moderate compensation for most accident victims. This contrasts with the American tort system, where the legal rules concerning both liability and non-economic damages are stated in general terms, leaving a great deal to the judgment of constantly rotating lay juries, which in turn makes courtroom outcomes variable and difficult to predict. Tanase's article noted that Japanese insurance companies, compared to their American counterparts, have much lower incentives to avoid full legal compensation. This is because the Ministry of Finance regulates insurance firms' rates, guaranteeing a reasonable return, and also establish compulsory loss-sharing arrangements among motor vehicle insurers. This made the insurance system more like a quasi-public social insurance program, Tanase argued, guaranteeing moderate benefits for the injured. The result was a system that is vastly more efficient and reliable in delivering compensation than the American tort system. Tanase estimated that legal fees comprised only 2% of the total compensation paid to injured persons, and that mediating and claims process costs amounted to about 0.2% of the total. In the United States, according to a survey in the late 1980s, 24% of individuals hurt in motor vehicle accidents involving potential defendants hired a lawyer, and the figure went up to 57% for victims with serious injuries. When the claimant hires a lawyer, the defendant or her insurance company generally employ a lawyer too. In consequence, according to two big studies of motor vehicle accident tort claims, payments to lawyers equaled 47% of the total personal injury benefits paid by liability insurers to third-party accident victims. This expense drives up the cost of insurance to the point that huge numbers of drivers are uninsured or underinsured, which means that victims of their negligent driving will get little or nothing from the tort system. All this makes Japanese bureaucratic legalism look very attractive from a comparative standpoint. But Tanase's 1990 article, foreshadowing his more recent scholarship, questioned whether a legal system that emphasizes bureaucratic smoothness and efficiency, rather than the pursuit of justice and responsiveness to changing values, is all a society should aspire to. The Japanese system, he pointed out, enabled especially aggressive claimants to obtain disproportionately higher compensation, and he feared that the low litigation rate and the emphasis on standardization would result in the stagnation of legal development, since courts were not constantly pushed to consider new arguments and improve the law. Thus, Tanase concluded, paradoxically, the very success of the Japanese elite in disarming the legal weaponry of the people inadvertently breeds the seed for its failure. The loss of legitimacy. Tanase elaborates on these themes in The Moral Foundations of Tort Liability, in which he adds an additional threat to the legitimacy of this system. People, he argues, want not only compensation for serious injuries caused by the negligence of others. Just as importantly, they yearn for a more humane, communitarian response, whereby tortfeasors face up to victims and reflect on how they may ease the victim's pain and suffering. Yet one might wonder whether Tanase's concerns, while normatively appealing, were and remained somewhat exaggerated. Property. Like several other civil law states, Japan places a great emphasis on the rights of the tenant, and landlords are generally not allowed to unilaterally terminate leases without just cause, a very narrowly construed concept. Many landlords are forced to buy out their tenants if they wish to demolish buildings to make way for new development. One well-known contemporary instance is the Roppongi Hills complex, which offered several previous tenants special deals on apartments. Despite this emphasis on tenant rights, the government exercises a formidable eminent domain power and can expropriate land for any public purpose as long as reasonable compensation is afforded. This power was famously used in the wake of World War II to dismantle the estates of the defunct peerage system and sell their land to farmers at very cheap rates. Narita International Airport is another well-known example of eminent domain power in Japan. Corporate law. Japan's current corporate law is based upon the Commercial Code as amended through December 30, 2005. Shareholder liability rules generally follow American example. Under Japanese law, the basic types of companies are limited liability partnerships, kabushiki kaisha, similar to an Anglo-American corporation, goda kaisha, similar to an American limited liability company, Gome Kaisha, similar to an Anglo-American general partnership, Goshi Kaisha, similar to an Anglo-American limited partnership.